Assalamualaikum warahmatullahi wabarakatuh. I'm Muhammad Muklis bin Muhammad Rawi. So today I will present to all of you for subject Engineering in Society for Chapter 5. So topic for Chapter 5 is Professional Ethics for Human Resource. So I will present it to you. I will present to all of you for subtopic 1 and subtopic 2. So let's take a look for the first subtopic, which is 5.1, which is Commercial Law and Industrial Relations Law of Malaysia, with special reference to the Law of Contract, Act 136. So, be written in the note that contract is an agreement between two people that is legally binding. Contract is the foundation or base of all commercial transactions, and a contract is idea from which both parties expect to benefit. So let me explain to you more detail about this. What is contract? So what is contract? Contract is an agreement between two private parties that create mutual legal obligation. Contracts may be written or may be written, and contracts also may be oral. However, written contract are generally easier to enforce. Some type of contracts may only be legally recognized with written contracts. So for example is a marriage contract and a contract that involves a huge amount of money. I will give you an example for the marriage contract. For example is Muiz said that he married to a girl named Masna. For example, Masna. Muiz married to Masna. And there's no written contract. Who will believe that? Even the girl family will not believe that Muiz married with their daughter. You need a written contract said that Muiz married with Masna, for example, so that people will believe that they already married. Nobody will believe if you go to a place and say, for example, to the market, I already married with, contohnya, for example, Masna, already married. Nobody will believe because you need the written contract say that you already married. Even if you married in the Thailand, they give you the contract say that you already married. It cannot be said just that I already married like that. So for the second example is a contract involving a huge amount of money. For example, Ahmad has a supplying the electrical appliances to the whole country, and suddenly a contractor want to buy Ahmad company electrical appliances with huge amount of it, so maybe a million ringgits of it. So to make sure that this business, this trade is protected, can be believed and protected, so they need a written contract. In case, example, the contractor take the electrical appliances but not paying the full payment of the electrical appliances, they bought from the Ahmad company, so that they can sue the contractor and take the case to the court. As I mentioned before, there is oral contract. Oral contract is a legally binding contract. So what is oral contract? Oral contract is a business contract that is outlined and agreed to via spoken communication. It is not written down. Okay. Although it can be difficult to prove the term of an oral contract in the event of breach. What is breach? Breach is pelanggaran. For example, is I'm making a contract with Ali and Ali breach the contract. So it is very difficult to prove because there is no written down contract. Okay. However, oral contract usually be used for the simple agreement, and it best to use for the simple agreement. For example, I want to use um, Ali car, and for the exchange, he think benefit it for the benefit of Ali. He want to use my chainsaw or my motorcycle. Okay, which is not require much detail. Very simple, with simple contract. So this will lower the chance in the case of breach that you need to go to the court. Okay, that's why for the more complex contract, such as employment contract, it is be written down because it is easier for you to refer if anything happen. For example, you apply to the Petronas as engineer, and you contract for 6 months. Okay, then it will written how long, 6 months, name, your salary, and what benefit you will get for the will be written in the contract. Okay, so I have said that contract legally binding. So let's see what is legally binding contract. So what is legally binding contract? We need to know what is legally binding contract, because in the Act 136, it's we state that the contract must be legally binding. So what is legally binding contract? Okay, so the binding definition of the binding itself is something that limits or holds someone to an agreement. Okay, a legally binding contract is a contract agreement that is valid under both state and federal contract laws. The term of legally binding refer to the requirement that both parties involved in the contract must obey the term detailed in the contract, as well as perform their contractual duties as stated in the contract. If one of the parties or both of them, usually only one of the parties, fail to do so, it will result in a legal consequences, uh, including but not limited to a damage award. Okay. Okay, in order for the contract to actually be legally binding, various requirements must be met. This requirement will depend on the nature of the agreement, uh, as well as the background of each party involved. If the contract does not require of being a valid contract, then it is said to be not likely a legally binding, which is a non-legally binding contract. And a broken contract is in a breach of contract lawsuit, which could then result in a damage award to reimburse the non-breaching party for any losses that they experienced due to the breach of the contract. So what is a key element? What is the key element that make the contract valid? Okay, a binding contract valid. So this is the key element. For the first one is offer and acceptance. So what is offer and acceptance? Is when one party presents something of value that they wish to exchange another party for something as value, there is an offer. And an offer, if someone give you an offer, and the other parties only have two choice. Either they accept the offer or decline the offer or reject the offer. For example, someone have for example employment contract. Okay, each company, engineering company, offer me for a 6-month contract or 1-year contract, employment contract, and I only can accept it or reject it. It's up to me. and you can read the benefit on the written contract. Okay. So for the second one is consideration. Consideration. What is consideration? Is the benefit that both parties gain or receive is from the contract. Contract is generally the consideration. Which can be, this consideration can be monetary or even can be monetary or even a service, object, or anything else that hold value. The third one is mutuality or intention. In a simple terms, means that all the parties involved in the contract intend to create a valid enforceable agreement. The next one is legality. Okay, what is mean by legality? In order for a contract to be valid, okay, it must not contain unlawful promises or consideration. Okay, a common, for example, for unlawful consideration is the contract. One side parties in the contract they say that they will do something against the law. For example, is rob a bank, robbery, or murder. Okay, that is that will not follow the key element to be a valid contract. Okay, and that is against the law, which is crime. Unlawful is crime. Okay, and it is not considered as valid contract. And the last one is capacity. Okay, capacity means that a person signing the contract has the legal ability to do so. And what happened if one of these key element is not be followed? Okay, it is called non-binding contract. Non-binding contract is an agreement that has failed because it is either missing one of the key element of a valid contract, or the content of the contract make it so that the law considered is unenforceable. Okay. Okay. So to make sure that all of you understand about what is a legally binding contract, so let's watch a video that I put in my presentation.
It's time to put together the contract, and you've got to know all of the elements that make your contract enforceable. Guys, pack your bags. We're going to go on this journey together and make everything you need to make this legit. All right, so now you've got the contract. You want to know what makes a contract actually enforceable, or what makes it valid. In our other YouTube videos, we've actually got some extra cool information on how to make changes to a contract and what really you should include in a contract. So click here, check those out. Make sure that you watch all 3 of these videos, because lumped together, you've got contracts covered top to bottom, A to Z. So let's ask the question, what makes contracts really enforceable? Well, there's some really specific things, and it might surprise you on how few there are that makes a contract legally binding. Now, just a disclaimer here, I'm not an attorney. Please don't take my advice as an attorney. If you ever have any questions concerning your contract, it's always a good idea to consult an attorney and get their feedback, and you can always take contracts over there to your attorney and have them check through them and all of that details. But all your contract needs to be legally enforceable, a contract really only needs 2 things to be considered legally binding. The first item that your contract needs in order to be considered legally binding, either if you need to take it into court, it'll be legally binding, are the parties involved. You need to know who is in the contract. And when we talk about the parties involved, you also would be wise to consider putting their names plus their emails plus their phone contact information plus their mailing address. Any form of contact info you have for any parties are going to need to be involved in the contract. So that's the first thing your contract needs to be legally binding, is all of the participant information on the contract. The second thing you need on a contract is the value exchange. When a contract gets made, it's because one party is over here saying, I have this product or service, and this other party is over here saying, great, I have money, take it, and we're going to swap. When that happens, a contract needs to take place to explain how those products and services are going to be delivered and how the money is going to be delivered back and forth so everything is kosher between all the parties. When that happens, you need to describe in detail how to do that. And if you watch one of our other videos, you're going to find out what needs to be included in that contract. There are several specific things we just advise that you include in the contract to make that as clear-cut as possible. Your contracts also need to be legal, moral, and ethical. Let me explain what I mean by that. You cannot make a contract illegal to the laws of the land that you live in. It's not a legal or contract. It won't hold up in court. It won't be enforceable anywhere if it's not legally abiding by the laws that exist in your state. That's a no-brainer, but consider getting very detailed on what the laws are. If you want to have some fun with this one, go and research really quirky, goofy laws all over the internet. They're crazy. I think, for example, in Arkansas, you're not allowed to walk across state lines with a duck on your head. I don't know why, but it's part of their legal system. So don't put that in your contract if you're in Arkansas for whatever reason. Your contract should include, in the body of the contract, it should be subject to the laws of where you live. So if you're in a contract and you're constructing a contract, make sure you have a line in there that says subject to the laws of this state or wherever you're in, if you're in the United States, or subject to the laws of whatever land that you live in. So in all of my contracts, you will find subject to the terms and laws in the state of Utah. You'll find that in all of my contracts because I'm just covering my bases, okay? So that's legal. Make sure that your contracts are all legal. Second thing is moral. You need to make sure your contracts, if you really want to have a quality contract, it's got to be moral. You cannot have a contract enforced that was signed by force. So as a crazy out there example, if someone was under a threat of life to sign this contract, that contract won't actually hold up in court. I know that won't apply to most of you, but just consider that if your contract is forcibly entered into, there could be a client that considers that contract was forcibly entered into. If there's any consideration for that at all, there's a good chance your contract won't hold up. Won't be hold up in court and won't be enforceable should your contract need to go to that position. Now, when I say ethical, your product needs to have the right value exchange within your contract. So before anyone enters into a contract with you, they need to know exactly what your contract says. How many times have you gone through either online or in person and clicked the box that says, I accept the terms and conditions of this, whatever it is you're doing, and you haven't actually read them? Do yourself a favor. Read them. Read all of them. They're eventually going to sound very, very similar, but there are some surprising things that you'll find in those acceptance of terms and conditions. Take, for example, Facebook. Now, a few years ago, there was a big to-do in the news and all over the place about Facebook Messenger and about how it was using your camera and about all these things it was doing, presumably behind people's backs. Now, there was a big hype about that, but remember that when you signed up for that service, not only was it a free service, but you had to check the box, I accept the terms and conditions of this product or service, or of Facebook specifically, before I can use it, which means that you agreed to that system when you started using it. Does that make sense? When you agreed to the system, you really don't have any choice but to abide by the terms of the contract. Now, this contract that you made between Facebook and you, or between Messenger as you and yourself, was a free contract. It was like, I'm going to give you this amazing service of being able to text and message and video chat with anyone all over the world for nothing. All you need to do is abide by the terms and conditions of the contract. All you need to do is check this box. Pretty easy contract to sign, but how often do we actually look at what's inside? To be a good, responsible consumer, read the terms and conditions that you're clicking. That's probably the most hours. You'll probably spend maybe 24 hours of your entire lifetime reading terms and conditions. I know it seems like a lot, but it's going to be worth it in the end. And you might even find that you are more likely to either sign up or not sign up, depending on the terms and conditions of the contract. The last thing that a contract needs to be legal, you've got your parties, you've got your value exchange, those are the two main things, but it has to be in writing. A verbal contract is not always enforceable. A handshake contract is not always enforceable. In fact, I gotta tell you, I was down in Costa Rica recently, and I heard about this real estate exchange of a man who had just celebrated his 100th birthday, and he got electricity on his land for the first time just 2 years ago. The funny thing about this was that the man bought the land for 500 colones. That's the currency that they use down in Costa Rica. And he bought it with 500 colones and a handshake. Now, remember, this is not like first world stuff. This happened several decades ago with just a handshake. Now, the fascinating thing was that 500 colones is equal to about $1. It's actually a little bit less. And he said, you know what? I'm going to give you a handshake on this. I'm going to pay you 500 colones, but I don't have all 500 now. As a matter of fact, I only have half. So I'm going to give you 50 cents, as it were. About 40 or 50 years ago, 50 cents, that's still not much to buy 17 acres of land. So he bought it for 50 cents and a handshake saying, I will pay you the extra 250 colones within the next year. For them, he enforced that contract, and that contract was paid, and it was done, and that the man owns the land for $1 now, and it's 17 acres of amazing land on the Costa Rica riverbank. But your contracts can't be like that, guys. This is a whole different world that we live in. You've got to have a contract that's written out in writing, and if you really want to have an effective contract, you're going to have multiple copies. Backup of your backup of your backup. I'm going to have a copy in my email address. I'm going to have a copy stashed away on my hard drive. I'm also going to take the time to print out an old school paper copy and file it away in my drawers and keep it with my documents. Sorry guys, you got to get a file box. If you're an entrepreneur, you're going to have to go out and get yourself a filing cabinet for all your amazing contracts. Now imagine going through a contract that was 17 acres of land. First of all, I don't know there's not many places in the US you can buy that anymore anyway, but imagine buying it for $1 and a handshake. Not even $1, like a half a buck, 50 cents down and a handshake. How do you feel if that contract happened to you? Would you feel like, that was enforceable? What if something happened to the land? What if you were the seller and the landowner said, oh, there was a flood and I lost half my land in this flood from the river that washed my home away and everything on it, and half the 17 acres is gone. I want my money back because I only have half the land. What are you going to do? You have no backup. You have nothing but a verbal agreement between two people that no one else was privy to and nothing in writing. This is one of the reasons, a very exaggerated example of why you want to have a solid, bulletproof contract. You want to keep that in mind when you're constructing your contract. If you're in a contract and you want to make sure it's enforceable, it is if you've got those key elements. Again, I'm not an attorney. Don't come to me for advice for attorney stuff. Talk to your attorneys. I always recommend that as backup. But again, contracts are very, very simple. They're easy. They're not overly complicated. You don't have to understand or speak legalese to understand the basics of a contract. This is super simple. Good luck with yours. Okay. Not as hard as you thought, right? So hit the subscribe button. I'm going to see you tomorrow, and we're going to be having a great conversation on how to boost more of your business.
Okay, so let's see what is the meaning of industrial relation law. Okay, the industrial relation itself means that refers to the relationship between the employers and the employees. Okay, so what is industrial relation law? Industrial relation law is an act to promote and maintain industrial harmony. And besides is to provide for the regulation of the relation between employers and the workmen and their trade unions, and to prevent and the settlement of any difference or dispute arising from their relationship. This generally means that to deal with trade disputes and matters arising therefrom. Okay, so what is the purpose of the industrial relation law? The most important one is to enable wage and condition of employment to be determined as far as possible by the agreement of employers and the employee at the workplace through the enterprise bargaining. And beside the important one is to provide a safety net of minimum wage and condition of employment. Okay, for example is Ali working in a huge electrical company, and this law protect Ali monthly wage in a net of minimum wage per month. For example is Ali monthly wage is 1,200 ringgit, and that is a net of minimum wage being protected by this law. Okay, so now let's take a look at what is a commercial law. Okay, commercial law is also known as a mercantile law or trade law, which is the body of law that applies rights, relation, and conducts of persons and businesses engaged in commerce, merchandising, trade, and sales. And it is often considered to be a branch of civil law and deal with issues of both private law and public law. Okay, it consists of two, which is private law and public law. And commercial law is effectively governs trade between businesses and consumers. It creates a regulated system that is fair for both parties, so that trade can be in a reasonable manner, conducted in a reasonable manner. So let's take a look at private law and public law. So for the first one, we look at private law. Okay, so what is private law? Private law is a part of is a common law that involves relationship between individuals, okay, such as the law of contracts and the law of obligation. Okay, so what is the branch of private law? The branch of private law is, for example, is the law of contract, family law, company law, which is more private, not for the society. That is what we call as a private law. Private law.
Hi, I'm just going to make a
So
quick
the next one
distinction
is,
between public law
public law.
and private law.
What is public law and how? What is public law? Public law is a law that refers to
So
the
public
part
laws are any
of the
laws
law
that have
governs the
government in part of that
relationship
legal
between
relationship.
individuals
So
and the
if government is
government.
affected by the law,
It's not a private
or
company,
if the
and
state
it's about
is affected
the
by an action,
exercise
whether
of
it's a
power and
person,
rights by public
company,
authorities,
and so on, as long as government is
including
affected
local
by it,
authorities
that
or
becomes
government
known as a public
departments
law.
such as Home
Examples:
Office.
constitutional law,
So
administrative
what are the
law,
example of
even
public
criminal
law?
law. So if
There
the
are
person
four
infracts
common
against the
type
state,
of public law.
the state will seek
The
to
first
punish
one
that
is
person. So it
constitutional law,
gets classified as a public law.
administrative law,
Private law, on the other
tax law,
hand,
and
governs the
criminal
relationships
law.
between individuals.
What
So
is
if someone has a
the
beef with someone else,
difference
or a legal
between,
matter involves two or
private
more
law and
individuals,
public law?
read into this companies, so
Okay,
it doesn't
the
have to be
private
natural
law
persons
is
here.
the
This gets
relationship
considered as
between
private laws.
individuals,
Examples:
such as the law
contract
of
law,
contract and the law of
torts,
torts.
family law,
And
and
the
so
public
on
law
are examples
is
of
the
even property
relationship
law of
between
individuals that might
individual
have an
and the
issue with each
state.
other.
Okay.
A
To make
certain
sure all of you
situation may
understand more
actually
about the difference
bridge
between
over
public
both.
law and
So you might have
private
an
law,
example
I will put a
where you
video
might, under the
and,
tort of negligence,
you will
someone
watch
has done
to
something
make sure
which,
that
has injured someone
you
else, and they are
understand more
seeking
about
to
the
recover
public
damage
law and
under
private law.
under the private law. However, the state may want to get involved and under criminal charges. A great example of that is if it's done in the workplace. WHS, workplace health and safety laws, come in as a state attempting to prosecute under those laws. So government can actually get itself involved in seemingly private disputes. The aim of the two, I guess, is government with the public law is aiming to prosecute generally or uphold civil order and make sure people do the right things by everyone, so we all play nice together. The aim of private law is more to, I guess, compensate against damage. So to restore an individual to the position they probably would have been in if they didn't have that issue with the other individual. Origins of both. I mean, most public laws are passed through Parliament, so they're more seen as Parliament-made laws, whereas most private laws generally tend to originate from, I guess, civil disputes. So previous cases, decisions from that, and evolve through what we call judge-made law. Seriously, in short, all you need to know, public laws affect government in some capacity, private laws don't. They're just matters within individuals. All right, hope that's made a clear distinction between the two.
For the last one, for the subtopic, 5.1 is which is the relation of commercial law and the industrial relation law to the Act 136. Okay, so what is Act 136? Act 136 also be cited as the Contract Act 1950. This act consists of 10 parts, which the first one is preliminary. The second one is the communication, acceptance, and revocation of proposal, which in this part it consists of revocation and how to make the revocation, revocation of proposals, acceptance, and promises expressed and implied. Okay, this part consists of that. So for the third part of is the contract, variable contract, and the void agreement. In this part, it consists of the what agreement are contract. The voidable contract agreement are void if consideration and object unlawful is in part. Okay, that example of the content in this part. And the fourth part is the contingent contract. Contingent contract. What is contingent contract? Okay, let me explain to you what is contingent contract, which is part of Act 136. Okay, contingent contract is a contract or not to the some event collateral to the contract does not happen. For example, okay, I will give you an example of the contingent contract. For example, Ali will of money when Abu married Masnah. Okay, Ali will to Abu some of money when Abu pay to Masnah. However, in this case, Masnah is without being married Abu, and this contract become void. Okay, that is an example of the contingent contract, which means is contract to or not to do some event to the contract or does not happen. Okay, this is what contingent contract. The performance contract, which is what is cost of the term by is promise the appropriation of payment need to be formed, performance of the regular promise and so on. Okay, that's the fifth part. Is the next part is certain relation resembling those created by contract, which one of its responsibility of the goods and next consequences contract. Maksudnya pelanggaran contract. Okay, in this part is we explain about the compensation for loss or damage caused by breach of contract and compensation for failure discharge, obligation, assembly created by contract, and the cases listed is next. And the next part is the indemnity and guarantee. Indemnity is penjaminan. Okay, in this part the forbears to sue does not discharge continuing guarantee, and it's about the second the bank, and part is the agency. It's all what in the Act 136 there is a special reference by the law. This is okay. So let's go to the second subtopic of Chapter 5, which is legal requirement relating to recruitment. So for this section, the person in charge here is HR, which is human resources. Who is human resources? Human resources is used to describe both the people who work for a company or organization and department responsible for managing all matters related to the employees. Um, there are four recruitment process, which is defining the role, attracting application, managing application and selection process, and making the appointment. So there is the key to the key of legislation regarding of the recruitment and the selection. Okay, the first one is the Equal Pay Act 1970, the Sex Discrimination Act 1975, the Race Relation Act 1976, the Disability Discrimination Act 1995, the Employment Equality, Religion of Belief, the Regulation 2003, and the Employment Equality, Sexual Orientation, Regulation 2003, and so on. So, let's understand what is the meaning of legal requirement. Legal requirement refers to the process required to find and place suitable candidates for an active job, as well as the art and skill of closing, the placement, the act of employer and the candidate signing contract. Okay, so how you defining the role? Okay, defining the role means that you're hiring the right people for the job. Okay, from the beginning, having a clearly defined role will enable management to identify the type of people they will need. Okay, so they can proceed to targeting and hiring the most qualified candidate for the job. So, why is very important to defining the role? Because it will give a huge impact to the company. Okay, uh, the first effect is because it will develop a strong team. What is mean by this? Teamwork is one of the vital ingredients in organizational success. And some teams are composed of individuals who know what they are supposed to do and what they are responsible for. If management is able to communicate to its team and team members their responsibility and accountability properly, then they will have a stronger teamwork, leading to a higher productivity and better result for the company. In a nutshell, it will improve overall effectiveness and efficiency. For the second one is attracting application. For this section, there is so many law of contract, especially to this attracting application. For example, is working time regulation, um, the law on minimum wage, the Human Rights Act, the Anti-Discrimination Legislation, the Race Relation Act 2000, and so on. There's many act related to this attracting application. So, what are the best strategy of the attracting application? What are the legal attracting applications? Okay, for the first one is the one of the way assess your application process. Be sure it's easy and straightforward. Okay, for example, is there should not be too many steps. If they are consider moving some part of the application to later in the hiring process, applicant don't want to jump through an inordinate number of hoops just to be considered for an interview. The most important one is you need to list the salary range on the job posting. This simple act can let potential applicants know they are not wasting their time applying for a job that will not pay enough for their needs. It can mean that someone who was on the fence will now apply. It also means you show up in the more search result for people who search by salary. For the next recruitment process is managing the applications and selection process. So for the first one is advertise job opening for recruiters. The second one is review every step of your recruitment and selection process. Determine how much staff time is devoted to assessing applicant information. Whether the recruiters are conducting preliminary telephone interviews to save time and expense in narrowing the field of qualified applicants. Number 3 is calculate your company outsource function such as background investigation, drug testing, job skill examination, and personality assessment. Number 6 is obtain feedback from hiring managers on the recruitment and selection process. Ask them if they benefit from recruiter recommendations. And the last one is create a process manual for recruitment and selection function. And the last one is making the appointment. Making appointment is the act of person authorized. Okay, and the appointment must be made. The appointment must be made in a such manner as to come within a such manner.
The recruitment process is a time of great opportunity for your organization and team members. At the same time, employment and hiring decisions are high stakes for both the employer and potential candidates. A number of legal protections have been established to ensure that the process is non-discriminatory. A truly open and competitive recruitment process is not only legally correct, but works to meet organizational goals for a diverse and motivated workforce. This presentation will provide an overview of the policies and practices used by the state of Vermont to achieve a fair and legal process. The first test that you should apply to all aspects of your recruitment is job relatedness. We all know that intentional discrimination is wrong and prohibited by law, but we may unintentionally discriminate if we are not careful to establish criteria that are clearly and objectively based on the actual work to be performed. Job-related means simply that your requirements and decisions are clearly linked to the job being filled and the business needs of the organization. Your criteria must be ones that are objectively and factually based on the requirements of the position. A valid business necessity is present when the stated requirement has a direct bearing on the performance of the job. Any selection criteria that has the effect of excluding individuals who are covered by laws prohibiting discrimination must be unavoidable because of specific job requirements. The state of Vermont has an equal employment opportunity policy, which includes a commitment not to discriminate in our employment practices, including recruitment and hiring. Stated in terms of compliance with the law, we do not discriminate on the basis of a protected category, including race, color, religion, ancestry, national origin, sex, sexual orientation, gender identity, place of birth, age, or disability. Stated in positive terms, beyond avoiding discrimination, we promote best practices that support an objective and inclusive recruitment and hiring process. Being inclusive is a good way to think about striving not just to avoid discrimination, but to actually promote fairness and diversity through our recruitment and hiring processes. There are many dimensions to a diverse workplace and many ways in which a diverse workforce benefits an organization. In the state of Vermont, we have 3 specific protocols that hiring managers must follow to ensure that all candidates have an opportunity to compete for our jobs. These are veterans preference, mandatory interview, and reasonable accommodation. Veterans preference is provided under state law, and there are 2 ways that we support qualified veterans to compete for state jobs. The first strategy is to give veterans extra points on their state of Vermont application. Each job opening produces a ranked candidate list. all qualified candidates receive a minimum of 50 points. Up to 50 additional points may be assigned based on preferred qualifications. Those who are eligible for Veterans Preference receive an additional 5 to 10 points. When prioritizing candidates for interview, consideration should be given to total points assigned to each candidate. Veterans Preference does not establish the right to a mandatory interview, but we do encourage hiring managers to consider veteran status when determining who to interview. The second strategy is to open state promotional job postings to veterans. Job postings may be open to all candidates, open only to internal candidates of the department or agency, or state promotional. If a job posting is state promotional, only veterans and state employees who have completed original probation are eligible to apply. Applicants with a qualifying disability may request mandatory interview status. Once the applicant is granted mandatory interview status, that will be noted on the candidate list when the applicant is routed to the hiring manager. If an applicant with this status is referred to you, he or she must be offered an interview. This does not guarantee the applicant the position, merely the opportunity of an interview. The question of reasonable accommodation may surface either during the interview process itself or in discussing the requirements of the position. An applicant who needs accommodation in the job interview process will generally communicate that need directly to the hiring manager at the time the interview is scheduled. Interviewers should be as flexible as possible in providing accommodation. If a request is unreasonable or burdensome to accommodate, it is advisable to discuss it with your HR representative before responding to the applicant. With respect to the requirements of the position, the best practice is to provide all candidates with a description of the essential functions of the position and ask them if they can perform those functions with or without reasonable accommodation. If a candidate indicates that some accommodation will be required, you can discuss the specifics once you've made a conditional offer of employment to the candidate. Using a structured interview process is a best practice to ensure that your hiring decision is both fair and sound. Structured interviews also have the advantage of creating a better impression with applicants than more subjective approaches. The elements of a structured interview are covered in detail in the Guide to Interviewing and Reference Checking, which is posted on the DHR website. The three basic parts of a structured interview are having questions prepared in advance, using an interview panel, and knowing how you are going to evaluate the candidates. The questions must be job-related, and all applicants are asked the same questions. Of course, a good interview is a conversation, and it is appropriate to ask follow-up and clarifying questions to fully assess each candidate's unique responses. An interview panel is most effective when diverse viewpoints are represented in the group and the members have training in how to conduct an effective interview and selection process. Interview panels are typically 3 to 5 people, depending on the level of the position being filled. Define your evaluation criteria before you enter into your interview process. This includes knowing how the interview questions connect to your job requirements and having a tool for assessing candidates' responses. Documentation is an essential part of all human resources activities, including recruitment and hiring. Documentation is used for data and tracking, as well as for research in the event that complaints or other issues arise. Good records also save time in the future when you want to reuse a job description or interview questions. There are two aspects of documentation that hiring managers need to pay attention to. The first is record keeping, and the second is ensuring that required documents are obtained prior to finalizing an offer of employment. VTHR is designed to be the system of record for applicant data. The hiring manager's role in maintaining that data is to update applicant status to know all candidates who were selected for interview. The hiring manager is also responsible to update the status of routed applicants once the decision has been made not to pursue the candidate further. The recruitment checklist for hiring managers posted on the Human Resources website specifies the actions to be taken. Your HR representative or the recruitment office can answer any questions and provide training as needed. A number of paper records are also generated during the recruitment and selection process. The hiring manager is expected to retain all of these documents for at least 3 years. This includes all interview notes and the tools used to prioritize and select candidates. For that reason, it is important that all notes are professional in tone, job-related, and free of personal comments. There are several inquiries that must be made prior to finalizing an offer to a candidate. In general, the tax compliance check is required for all new hires, but does not apply to active state employees. Any offer of employment is conditional pending a review of the applicant's standing with the tax department. The criminal history declaration form must be obtained prior to any job offer. Applicants may be asked to complete the form after the review of the application and first interview. Background check requirements vary by position and department. Please check with your HR representative to determine what pre-employment checks are required in your department. To recap, you can ensure that your hiring practices are legal and consistent with state policy by following a few simple guidelines. First, make sure that your requirements, selection criteria, and interview questions are all job-related. Second, be inclusive. Be aware of candidates who qualify for veterans preference or mandatory interview. Be flexible in providing reasonable accommodation when requested. Provide candidates with the essential functions of the position and ask if they can perform those functions with or without reasonable accommodation. Third, follow a structured interview process with prepared questions, an interview panel, and clearly defined selection criteria. And last, keep good records and make sure that you have conducted all applicable pre-employment record checks.